This is not about the individual mandate or the future of health care, significant as it is. We're really talking about preserving our distinctive constitutional architecture. The point we dwelled quite a bit on our pleadings and in the oral argument. You need to make sure that what Congress is trying to do is subject to a meaningful limiting principle. Not just a limiting principle, but a meaningful limiting principle. Let me just add one last point, but there is a only difference between our case and Virginia's case is that we are also challenging the Medicaid-related provisions of a statute. That major count survived the motion to dismiss phase, and we are hopeful that we'll prevail on it as well, in addition to individual mandate. But we're basically arguing that the way in which the federal government has recarved the mandatory core of Medicaid it results in such additional expenditure of state resources as to present a real problem. A problem in a sense that there's a third way of destroying state sovereignty. One is commandeering on the New York and Prince. The second is pulling out all the regulatory oxygen and leaving state with, a husk, if you will, completely at the mercy of federal government with no independent regulatory authority. And the third way is turning the state into a financial bankrupt, into a financial husk, into a ward of a federal government.
It's a valid revenue measure. It's a regulation of participating in the healthcare market without maintaining adequate insurance, which virtually everyone does. And it is absolutely essential as being necessary and proper to carry out the regulation of 1/6 of the economy in the critical respect of forbidding the denial of coverage to people with pre-existing conditions. To overturn this law on the basis of a different economic theory would, I think, be everything that conservatives have always abhorred about having the courts substitute their views for that of the political branches of government. Thank you.
Thanks, Walter. I think I can speak for all of us here today in acknowledging that we've been transported to the front lines, the trenches of the battle that's taking place over this particular legislation.
But if the bill is built on an unconstitutional foundation, it should not stand, however good whatever is in the bill is. And all complaints about that should be directed to the legislators who first swore an oath to uphold and protect the Constitution and then voted for this bill, because there was a constitutional way to achieve the goals in this bill, and they chose not to do it.
I think it's really staggering to think that we could be the only...
Careful, I'm not saying that. I'd still say it's not a tax.
Right.
Even if they said it was a tax.
Correct.
Right. Well,
Still has to be
a lot of emphasis placed on the word change. It seems to me to say that we'd be the only modern developed country without a national health care system because Congress changed a three-letter word to a seven-letter word is a staggering idea for courts to adopt.
Yeah, and we're not saying that.
Yes.
Does it matter whether it's a tax or not in any literal sense when it's part of Congress's revenue-raising powers under Article 1? I mean, is this angels on the head of a pin? I'm not talking about your argument that it's a direct tax, it's a capitation, which is almost too complicated to go into here, but just on the basic argument. If Congress is raising revenues through an amendment to the Internal Revenue Code in order to provide for the general welfare, why are we in this head-of-a-pin debate about tax rates?
Very briefly, General, back to the limiting principle. Under your logic, and we said it in our papers, every federal statute in a book has civil penalties, every one. Under your logic, all you need to do is to take that statute, take the civil penalties out, put it in Internal Revenue Code, and everything that SBA, Agriculture, EPA, FCC, FERC does would be converted into a tax, which, by the way, you could not challenge under the Anti-Injunction Act. That is not how the system works. Tax has... to say that something is a tax is not enough to say that it's capable of producing revenue. Any payment of penalty, then you pay EPA $25,000 per day per violation. That produces revenue. Is that a tax? No. Why is it not a tax? Because the previous Congresses were dumb to put it in the Clean Air Act amendments and didn't put it in the Internal Revenue Code? Under that logic, every regulatory exaction would become a tax.
That's a radical position. That's a very radical.
David is a radical?
No. No, the notion that all you have to do is have a way to raise dollars, to get dollars to the government, and thereby make it a constitutionally allowable tax is a radical concept.
Point taken. Yes, sir. And I will close with my usual admonition to stay tuned. In particular, stay tuned to the Washington Legal Foundation, because this surely will find its way onto our agenda in future Supreme Court discussions when, as, and if, as it appears to be highly likely, this issue is before the court. So thanks again, gentlemen. We appreciate it.